See people starting to come in now, so we'll get things started. We've got a lot to get through this morning, which is terrific. So, hello and welcome again. My name is Mitchell Zaddo. I'm the Managing Principal here at Sharrock Pittman Legal, and thank you very much for joining us for our webinar today on legal and other commercial issues to do with petrol stations and petrol station businesses. Before we get started, we would like to acknowledge the Wurundjeri people of the Kulin Nation as the traditional owners of the land on which our office is located, and we pay our respects to their elders past, present and emerging, and acknowledge that sovereignty was never ceded. And we extend this respect to all First Nations communities throughout Victoria and wherever you may be logging in from. So I know many of you have attended our webinars before, so welcome back. And if it's your first time, then an especially warm welcome to you. And we hope these webinars are being a really helpful resource for you. It's an opportunity for us to share with you some things that we're seeing coming up frequently in our day-to-day practice and offering some guidance on different topics that might be of interest. You can catch up with recordings, of course, for these webinars on our website. We'll have more details of that later on. And you'll find there the webinars that our lawyers have been doing on all sorts of topics from commercial law, wills and estates, employment law, not-for-profit, and of course, property law. So if you don't know much about us at Sharrock Pittman Legal, we are a boutique commercial and property-focused firm. And we have accredited specialists in these areas and in wills and estates as well. So we're able to dive deep into these things with a lot of expertise and experience. But today we're looking at issues around petrol stations, and they're obviously a very specialised and unique type of business and type of premises. So we've put together a team of experts to share some things that we think you should be aware of. And even though the focus today is on petrol stations, some of the things we'll discuss are adaptable to other types of businesses and premises too. So I'm joined by Shubha Rao and Miraz Sidhu from our team. Shubha is a senior associate in our property law team, and Miraz is one of our commercial lawyers. And we're very fortunate to be joined by special guest Joshua Fulton from Opteon Property Group. Josh is a director in their specialist valuation and advisory services team with 18 years experience in commercial real estate valuations. He provides valuations of commercial and industrial properties within the southeastern suburbs of Melbourne, and he's worked in their specialist petroleum division now for over 7 years, undertaking valuations in Victoria and interstate as well. So his client list includes all the major lenders who lend on petroleum assets, large petroleum network groups and developers, and corporate clients such as Viva Energy, Ampol, Liberty and 7-Eleven. So we're very lucky to have Joshua joining us today and sharing his expertise. So thank you very much, Josh. Before we begin, I'll hand over to Shubha shortly to start sharing what we'll be covering today. I'll just run through some housekeeping items. We are recording the session. We'll be on the website and we'll let you know when that's available. So if you miss something, don't worry, you'll be able to catch up later. And if you have any questions throughout the session, please feel free to type away in the Q&A box. We might try to cover some questions on the way, but we'll definitely cover them at the end. So if we don't answer your question straight away, don't worry. I'll just be saving it to cover at the end because it might also be something that we'll cover in a later slide. We are conscious of time though, so if we don't get to all of your questions, don't worry. We'll take a note and get back to you on anything that we can't cover before the end of the webinar. One final thing from me before I hand over to Shubha. We are lawyers after all, so we do need to put up some fine print. Needless to say, we can only give some general guidance in this session. It can be a very complex and technical area, just by its nature, of course. So everyone's circumstances are different. Every premises is different, and that's really important to keep in mind when you're thinking about your own situation. So if there's anything we're covering today that you want to talk about in terms of your own circumstances, just feel free to get in touch with us afterwards, and I'll put those contact details back up again at the end. So thank you for joining us again, everyone, and I'll hand over to you now, Shubha. Thank you.
Thank you, Mitchell. So just as a general overview, so you're on the session overview slide, Mitch? All right, yeah, so just on that one, so we're just going to, with regards to petrol stations, we're just going to cover these topics going there briefly. So basically documentation that would usually come across for a petrol station business. the business operation models that a petrol station can have, reselling agreements, oil code of conduct, and also lease and license terms and conditions, as well as what to do if you're selling and buying land that has a business station, a petrol station business on it. Joshua will then talk about lenders' perspective for petrol station businesses. And my colleague Miraz will talk about sale and purchase of petrol station businesses and how franchising can come into this model as well. Next slide, Mitch. So in terms of the documents,
you might need to check your view settings, Shruva, in case there's something there.
Yeah. All right, I'll just speak to my slides. So the documents that we've got, so a franchise agreement, it's normally that a lot of these businesses are operated by way of a franchise. So Miraz will speak to that later on in this presentation. There's also commission agency agreements and fuel reselling agreements, as well as leases and licenses to occupy the premises. Next slide, Mitch. With regards to the operation of the business, so I guess there's three models in which an operator of a petrol station can conduct the business. The first one would be as an independent business. This is where the operator would own the business themselves, and so they reap the benefits of profits of the business, and they have the ability to secure fuel from any fuel supplier that they wish to contract with. And as a franchisee, the operator does own the business as well, so they'll still reap the benefits of profits, but the fuel supply would be limited to being required to be purchased from the franchisor. Usually the franchisor would be a national fuel provider like Caltex, Shell, Pole, one of the bigger ones there. These businesses can be operated as a commission agent as well. So the operator will not own the business, but it acts in the capacity of an agent who sells the fuel products and like the inventory that might be there in the store. So the agent will then receive payment in the form of commission for the sales that's actually occurred on that premises there. Next slide, Mitch. So reselling agreements. So what is a fuel reselling agreement? A supplier agrees to supply petroleum products to a retailer, and a retailer is the business that on-sells petroleum products to the end user or consumer. The usual characteristics of a fuels reselling agreement are that the supplier will grant the retailer the ability to conduct the fuel reselling business. The business will operate under a system of marketing plan that is determined substantially by the supplier. The business will be associated with a trademark or commercial symbol, advertising, marketing, that's all provided by the supplier themselves. And prior to starting the business, the retailer will also generally pay a fee to the supplier. A franchise agreement that allows within its body the resale of fuel products would be considered a reselling agreement. A commission agency agreement that ticks off points A, B, C, but doesn't really have any fee that gets paid for the business there, that will still comply with the requirements for a fuel reselling agreement and would be treated as such. So what is the impact of being treated as a fuel resale agreement there? The oil code of conduct will apply to such agreements. So where the retailer sells more than 30,000 litres of fuel per month, this oil code of conduct will apply. The agreement applies to all parties involved in such a transaction, like it'll be suppliers, distributors, or even the retailers of the fuel. There are a couple of aspects with regards to a fuel resale agreement that the Code of Conduct governs. So there's a minimum duration for the length of that resale agreement. Generally, they must be for at least 5 years long, unless there is a circumstance where the lease for the site is less than 5 years. Then you're allowed to have a shorter duration. If the resale agreement actually requires a retailer to buy fuel from a supplier that actually owns the site or leases the site, then the agreement must actually have an option to renew as well, and that option to renew must be for at least 4 years. So in that circumstance, there's about 9 years in total that they actually have the duration of the agreement for. There are also disclosure obligations that are required before the agreement is entered into. You'd have to provide a copy of the oil code. There's a disclosure statement that needs to be provided, as well as a copy of the resale agreement is to be given to the retailer at least 14 days before the agreement is entered into, or the retailer pays a non-refundable money to the supplier as part of the agreement there. The oil code sets out what information is required to be provided in the disclosure document there. So if the agreement is for more than 5 years, then all the information required in Annexure 1 is to be disclosed. If the agreement's for less than 5 years, then Annexure 2 there. So it's a short form disclosure for the shorter duration agreement. Once the agreement is signed, there is a cooling off period that is available for a retailer. So there's a 7-day cooling off period there for a new resale agreement that's actually entered into. If there's a termination at this time, then any money that must be paid, that has been paid by the retailer, should be refunded back to the retailer, minus any of the supplier's reasonable expenses that have been incurred there. The code also governs what needs to occur if there's a transfer of the fuel reselling business there. There is another disclosure statement that needs to be provided to the proposed transferee, and that's in the form of Annexure 3 in the code. The code also governs how the agreement may be terminated. There are a number of circumstances where a supplier is able to terminate the agreement, as well as a mutual termination by both parties. The oil code also contains references to terminal gate pricing disclosure. So that's for sales from a wholesaler to a customer. And so a customer there is defined as someone who is a retailer of fuel, or someone in more of a distributor capacity there. And so that terminal gate pricing enables that customer that's buying from the wholesaler to elect what price that they're going to be buying the fuel for. Next slide, Mitch. So the next important one that we need to talk about is sort of the actual premises itself, where that the business is going to be operated from. So the business can occupy the premises under 2 types of documents. So one is a lease or a license that's there. So generally, if there's a franchise agreement there, then most of the time a franchisor would have taken a lease for the site, and then they provide a license to occupy to the retailer there. But if there's an independent business, then yes, you're able to go and approach a landlord directly and obtain a lease for there. So the first component of leases that's quite important is whether the Retail Leases Act will apply to your circumstance or not. So if the tenant is, say, one of the big franchisors, then as a public company, the Retail Leases Act would not apply to them. The duration of the lease is also a determining factor. If it's sort of over 15 years, and the lease imposes an obligation on the tenant or any other person to carry out substantial work on the premises and to incur those costs there, and then not be able to remove those items at the end of the lease, then that one would sort of fall out of the retail premises lease, Retail Leases Act there. For a license, generally the Retail Leases Act won't apply. The Retail Leases Act is preferential for tenants there. It's very consumer focused. So as a landlord, the ideal would be, one of the big firms like, Shell, Caltex, so one of those, so that land tax can also be claimed from them as an outgoing. But otherwise, under a license, yes, there is no protection to the tenant there, and it's all commercial negotiations as to what the terms and conditions are. A license also does not have any exclusive possession of the premises, whereas a lease does. It gives you an interest in the land. There are also premises that sort of have a caretaker residence on them. And so with respect to those more residential type of premises within the commercial site, they can fall in under the Retail Leases Act as well. But we have advised other clients previously where we've said to them if they can actually be separated out. This is to ensure that if there's any redevelopment on the site, the Retail Leases Act will then allow for compensation to be payable to the tenant there. So it would be best to try and avoid those sorts of scenarios. And if a residential lease can be covered for those particular points, then you can try and keep the two separate. The other big one is the ownership of fuel infrastructure and equipment. So these are the underground fuel tanks, fuel lines, and above ground pumps. It is important to determine who owns these items, because this will then dictate who's going to be maintaining and repairing these items there. So usually in a lease, like the underground fuel tanks and above ground pumps, most of the time they are owned by the landlord there. So they would be a landlord installation. If it is a new site, and then possibly the tenant might be able to have them as tenant installations, and the tenant then puts them into the site there. We have also come across leases where it does allow for a tenant to be able to install future tanks if they wish to increase the capacity on the site as well there. So then that would then just be, is that going to be a tenant installation or a landlord installation? The parties would then have to determine at that relevant point in time. Under a license, so the ownership there would then depend on what the franchisor might have signed off on in terms of their lease there. With regards to the maintenance, so usually the maintenance of all the fuel infrastructure and equipment would still come across to the occupier on the property. So anything other than structural repairs, the tenant would still be required to maintain and make sure that there's no leakages there. Any structural repairs would then fall on the landlord in terms of if there's going to be any replacements or anything like that. In terms of environmental considerations that are there, an environmental site assessment report is usually recommended at the commencement and at the expiry of any occupation of the premises. It's required to set the baseline to determine what the make good obligations are for the party. In terms of who pays for the environmental site assessments, we've been party to negotiations where the parties have agreed that the landlord will pay for the first one, and then the tenant pays for the one on the expiry or termination of the lease, or both parties agree to pay for both of them and share the cost there. So that is up for commercial negotiations as to how that's actually done at the time. In terms of environmental obligations, so leases and licenses will usually contain obligations where the occupier should not be causing contamination on the land. And also, there'll be notification obligations if they do determine that there is some leakages on the land. So as part of the environmental obligations, a tenant will need to comply with all relevant environmental laws that are applicable to the business. And it would need to have systems and processes in place to detect leakages and to allow them to comply with such laws. So normally, things like daily dips that get done, checking of all the equipment, above ground equipment, the pumps and things like that, just to make sure that they're all in good working condition. Checking for any water contamination in the fuel, and also any SERA reports or other similar reports that can show if there's any loss of fuel there. So if there's any of those items indicate any leakages, then there should be any contamination should then be investigated. And if it's found, then the EPA would need to be notified at that particular point. The EPA does have the ability, so if there's significant contamination, serious contamination, they can issue notices to then require immediate remediation of the site there. So they can ask for no trading to be done until the site is fully remediated to their satisfaction. Given the nature of the business, there's also lots of occupational health and safety considerations that need to be accounted for. There's dealing with dangerous goods and things like that. So in terms of training of staff and the handling of all these matters, and even safety of consumers that come onto the premises in terms of no mobile phones. Those types of things need to be followed through there. So usually leases and licenses will place the obligations for that on the occupier of the premises there. Also, you need to ensure that there's no actions that are undertaken that will cause the landlord's insurance to increase or for the property to become uninsurable for any reason as well. In terms of the make good obligations there, yes, so generally the property should be brought back to its condition as at the commencement of the lease, except for fair wear and tear. So this is where the ESA report, the expiry will come in and give an idea if there has been contamination over the period of time that the occupier has been in the premises. And if so, then what needs to happen to remediate that land there? Generally, we've negotiated where there's time after the expiry of the lease to allow for the report to be provided and remediation to be done. But we didn't say during that period of time, rent and outgoings will still need to be paid. However, there's no trading allowed on the site. Some parties have then gone, no, they don't want it extended, so they bring it during the lease term, but you will still have a period of time where no trading can be done, so that you can then undertake any remediation processes that are required there. Another component of leases and licenses is whether you're allowed to sublease or license the premises to other complementary businesses. I'm sure you're all aware there's there's like Hungry Jack's, McDonald's at petrol stations, kebab shops, and things like that. So are you allowed to do that under the particular occupation agreement that you've got? Or would you want to bring such other businesses on and things like that? So that's definitely a consideration that needs to be undertaken at the time that you're looking at the land. So next slide. With regards to sales and purchases of land that have a petrol station business on it. So if you're just buying just the land, you'd still need to comply with material facts disclosure. So while an ESA is generally not required to be provided in your contract and disclosure statements, if an ESA has been obtained prior and indicates that there's been a leak or contamination, and these have not been fully remediated at the time of sale, then that disclosure would need to be provided to the proposed purchaser as well. And there would then need to be negotiations on which party is going to be undertaking what aspect of the remediation, whether it's going to be the vendor's full responsibility, or if there's going to be a shared obligation there, which then reflects in the purchase price. Any notices that have been served on the premises, council notices, EPA notices, do also need to be disclosed to the proposed purchaser at that particular point in time. One of the other important parts is the contamination clause in a contract of sale. This would be very important for a vendor to keep as broad as possible. So usually a purchaser would undertake due diligence on the land, and if there is no ESA report that's provided, a purchaser would obtain their own ESA report just to confirm that they are happy in purchasing the land there. So generally in the contracts, any latent and patent defects are a purchaser's obligation there. But if there's been a failure to properly disclose, then it does reflect on the vendor, and the purchaser may have a termination right there. Yeah. In terms of consent requirements as well, so under the fuel reseller agreements, there are usually requirements that if the supplier consent is going to be required before there is a sale of the property. If the agreement is going to be assigned or transferred, then the supplier's consent will be required, and there might be an approval process as well for them to then acknowledge who the new person is actually going to be coming in. There's also duty considerations for sale of land that have businesses on them. So where there are transactions involving properties that are more than $1 million in price, the SRO can require a valuation to be provided if the transfer of land and the transfer of business occur at the same time. So then the value of the land, improvements on the land, and the business and the goods exceeds 1 million, then a valuation would be required. This is generally because on sales of businesses, there's usually no stamp duty that's payable, and so the SRO looks at it as a whole to go if they're both changing, then there should be a value that's attributable for the business on the land. In terms of transfer of land also, you do need to be careful, because if there has been a prior transfer of land within prior transfer of business within the last 12 months, then that can be caught up within this requirement as well for valuation to be provided and for stamp duty to then be assessed with regards to the value of the previous transfer of business as well. It does cover a future transfer of business too, if there was one even 12 months after the sale of the land has occurred. So there would be a notification that would now need to happen and be provided to the SRO for them to then reassess any stamp duty that would be payable. I will now pass you on to our guest speaker, Joshua Fulton, to speak to you about valuations.
Thanks, Shuba. Thanks, everyone. I thought I'd just touch on today just some of the common things we face as valuers when valuing these service station assets, and some of the common hurdles which we come across. Most of these are to do with environmental matters, which Shuba just touched on. Banks are really hot on environmental matters when they look at these types of assets. And one of those things that we look at is really what's the risk profile of the site. Is it a new site where you've got modern fuel infrastructure with double-walled tanks, non-metallic fuel lines, you've got your AT automatic tank gauge consoles and the like, or is it an older site with older fuel infrastructure such as steel tanks, steel lines, which present a far higher risk profile? In particular, the steel lines, if the site is going to fail in regards to fuel infrastructure, it's usually going to be in the lines. So that presents a much higher risk profile and something that we as valuers and certainly lenders have regard to as part of their considerations. We also take a look at what environmental reports are available. Ideally, we'll have an environmental site assessment available. If it's a lease site, it will usually be in the form of a baseline environmental site assessment, which will be attached to the lease. You may also have tank and line integrity tests, SIRA reports, which is your wet stock inventory reports, groundwater monitoring event reports. These are all things which add up together to provide an overview of the environmental status of the site. And again, it's risk profile. Now, these reports and what we require or what we suggest depend on what the site is. If it's a modern site with a major tenant covenant, major oil company tenant covenant in it, they will pretty much always have a baseline ESA. If you're looking at, say, a country site with a small operator, you may not have a baseline ESA report. The owner may not have an ESA report at all. And therefore, with those sites where you might have steel tanks, for example, and steel lines, we would certainly recommend that you undertake an environmental site assessment, and particularly a phase 2 ESA as part of your due diligence. And the banks will certainly require that as part of their lending. They won't look at those sites without having access to those reports. And that's around the experience that the operator has with that. Obviously, if you've got a major oil company, we understand that they operate under best environmental practices and undertake all of those reports, all of those wet stock inventory checks, groundwater reports usually done every 2 years and the like. So it provides far more comfort to the operator when you have one of those major tenant covenants in place, or if it's an operator who's a large operator in the industry, such as a United, Liberty, Jasby, all of these larger operators with 50, 60, 70, 80, hundreds of sites around Australia. That's around the strength of the tenant covenant. Obviously, with the major oil companies as well, further touching on that is you can have a fair bit of comfort if something does go wrong, the site is contaminated. If you've got a Viva Energy or a BP, Ampol, Caltex and the like, they have the financial resources to be able to remediate the site and pay for the remediation of the site. If you have a smaller operator in play, the risk profile is a lot higher. Obviously, under the guidelines, the polluter generally pays or does pay for any contamination, but there's nothing stopping that operator going into bankruptcy, and suddenly you're left with a heavily contaminated site. So that's certainly something to consider, and that's why you see those major oil company lease covenants achieve a far higher price and certainly a far tighter yield compared to your lower tenant profiles. Under the lease, what are the requirements of the tenant to remediate the site? As Hubert touched on, most of them have it where you have to put it back to the baseline ESA report as a bare minimum. And other options are sometimes it's return it to highest and best use under the planning ordinance, or it might be to put it back to a state suitable for continued service station use. So just have a look at those terms in the lease and what the requirement is. There's obviously a higher risk profile when you're dealing with sites such as a residential planning zone, which are suitable for a more sensitive style use. If the highest and best use beyond the service station use is for residential, for example, or childcare centre or the like, you want to make sure that the lease covers off on that, provides the ability to remediate the site back to that level that allows that potential. Alternatively, or as opposed to industrial zone, obviously within the industrial zone, you don't have as high a risk with that compared to your residential zone. Generally, industrial uses have a far higher trigger in regards to the environmental status which they could be developed on. So, we don't have as many or as much concerns in regards to industrial zones as we do residential, but certainly something to consider. It adds to the overall picture. One thing which I've come across in recent years has been the PFAS contamination, and this is in regards to fuel depot sites. It's something which a lot of the environmental site assessments, they don't necessarily test for PFAS. It's something which on depot sites, in the past in particular, it's been common that they have fire training drills and they'll spray this chemical as part of that. PFAS is extremely difficult to get out of the soil and the groundwater, and it costs a hell of a lot of money to get out of. So it's something just to consider if you're looking at these older depot sites. Just make sure that you cover off on that, because it could lead to some significant remediation costs beyond your standard fuel contamination risks involved with that. The other consideration is, does the property have a high or low underlying land value, and what risk profile does that present? If you have an older site out in the country, the land value might be worth $200,000-$300,000, and if there's any contamination at that site, the cost of remediation can quickly exceed the value of the property. So that's certainly something to have a look at, and make sure that all of your leases have the required clauses to best protect you against that occurring. As I said, less of a concern with metropolitan sites. We generally have a stronger underlying land value, but it's quite common, and I've seen a number of sites where the cleanup costs have been, in excess of $1 million to remediate a site. And as you can imagine, if you've got a site worth $200,000-300,000 in the country, you're quickly in the negative territory. So just something to consider. Next slide. Thanks, Mitch. So next, I just wanted to touch on some risk mitigation techniques, which we've come across as part of our valuations. In addition to what I just mentioned on the previous slide, make sure that the lease has, as I said, adequate coverage in regards to the environmental obligations of each party. I've seen quite a few leases for mostly older style country sites where the leases will have little or even no clauses in regards to their environmental obligations of the parties. For us, from a valuation point of view and from the bank's point of view, it basically stops the process in its tracks, and it requires further legal advice and usually binding agreement by both parties to provide guidance on who's going to be obligated to remediate the site at lease expiry. I've seen quite a few of these over the years, and there's too much grey involved and too much risk to the owner of the property and potentially to the bank if they were to repossess the property down the track. With older sites, there is a potential to reline fuel tanks these days, and that's rather than replace them, and that can save a lot of money, hundreds of thousands of dollars potentially. That can cost you tens of thousands of dollars. Replacing tanks is 5, 6, 800,000, depending on the size of your tanks and how many tanks you have. So that's certainly something we're seeing a bit more of with older sites, where operators are going in there and relining them. It is subject to the tanks having a certain thickness with them, and this is for steel tanks mostly, but certainly something to look at. The other one we see is they'll keep the old steel tanks if they're found to be in good working order through a tank and line integrity test, but they'll look to replace the lines instead with non-metallic lines. These tend to be the most likely to fail, so that's something which we see fairly often as well. And make sure you do your own environmental due diligence as well. Don't simply rely on dated environmental reports, in particular if it's an older site with a higher risk profile. Go through and do your own environmental checks, whether that be through another ESA, tank and line integrity test and the like. Be sure that you're comfortable with the operator and that they've operated the site appropriately. And make sure you just cover off on all of those due diligence. Don't assume that everything's okay, because at times it's not the case. Next slide, thanks. So next, just want to touch on some of the lender requirements and what we find, what feedback we get from them when we're doing these valuations. It's commonplace that lenders will want to cite a copy of the baseline ESA, or at the very least, or an up-to-date ESA. If the lease is a major tenant, includes appropriate remediation clauses and a baseline ESA may be sufficient. If there's no ESA or it's dated, the lender may require you to go through and get that full ESA, in particular for sites with older style fuel infrastructure. We find that, it's pretty much a starting point that the banks will want us to go and obtain that environmental site assessment, or for the owner, to obtain it and us to review it. We find that most ESAs will come back. I haven't had too many where they've come back with too many issues on it. It's general knowledge that all service station sites are contaminated to some degree. It's just a matter of to what degree, and so long as it's suitable for ongoing service station use and doesn't require remediation, it doesn't usually stop the process in the valve or cause any issues in that regard. It's just a matter of what those findings are and whether they trigger remediation requirements, which I've found to be relatively rare from the ones that I've done over the past 7-8 years. Added requirements, they might request for tank and line integrity tests if it's an older site with older fuel tanks and lines. They might want us to cite SIRA reports, which is your wet stock inventory, in particular for sites where we're valuing it for an owner-operator. They will generally have weekly or monthly SIRE reports done, and we'll note those in the report and note any consecutive fails during that period, any risks, and what the owner's done to fix those. Sometimes those fails can be due to weather fluctuations, input errors and the like. So that's all part of the picture that we paint for the lender to try and provide them some comfort. As I mentioned, the legally binding clauses around the environmental obligations and how they sit. As I mentioned, some of the leases have very few environmental clauses, if little, or provide a substantial level of grey in regards to who's required to remediate the site at lease expiry. And lastly, one of the things that we see with some lenders is they won't lend on sites with older style steel tanks and lines. So it's just something to be careful of if you're looking to acquire one of these sites. There's a couple of banks in particular that I know, I won't mention their name here, but they won't lend on anything with steel tanks and lines. It's too high a risk profile to them. So just do your own due diligence if you're looking to purchase one of those sites, that you have a chat to your banker and get some comfort that they'll be happy to lend on it, subject to obviously all of the environmental due diligence being done. And next slide. And lastly, just wanted to touch on some key valuation considerations, some of the things we look at as values when we're valuing these service station assets. And it probably depends on whether it's a lease site or an owner-operated site, but I'll touch on firstly more so leased sites. Strength of the tenant covenant is key, in particular in the current market. We're seeing investors rush to tier one assets, and who the tenant is it one of the major oil companies or one of the major retailers, such as a 7-Eleven, for example, compared to a lower tier tenant covenant with lesser experience and the like. We're seeing a gap emerge between those tier one and tier two, tier three tenant covenants. So it's certainly something which we have considerable regard to when valuing these sites that are leased. The lease covenants as well, what's the lease expiry, what's the WALE, recoverability of outgoings, as Shuba touched on. Most of them fall under the Retail Leases Act if they're not one of the major oil companies. So land tax is usually non-recoverable. At times, building insurance won't be recoverable as well, or it'll be split between the parties. But common practice is that all other outgoings are recoverable, save for structural repairs and the like, maintenance. What's the annual rent and market review provisions? Generally, that's CPI or 3 to 4% in the current market. Do you have the option for a market review? Most of these are at the end of the lease term, the initial lease term and any further terms. Some of the leases for the major oil companies may have a ratchet clause in it where the lease doesn't go backwards or can't go backwards. They're quite favourable in the current market because it provides only the ability for the rent to increase through the term of the lease, and the environmental clauses as well. Is the rent at market? This is always a difficult one to assess for service station assets. Rental evidence is wide and varied, and I do a lot of rental advice for Viva Energy and Ampol and a number of other operators and private owners. And you can have rents that support a low level and you have rents that support a high level. So it's quite a contentious area with rent reviews in particular when they come up at the end of the lease. It's fairly common that they go to determination, or there certainly gets very close to that determination process. So have a look at the rent, try and work out whether it's around the mark. Most of your new leases, if you're buying a fairly modern site with a major oil company, it will generally be thereabouts, and that's okay. But there have been situations where below market rents, have been in place. I can think of the not recent now, 3 years ago, 4 years ago, 7-Eleven and United sold a number of their own sites, subject to leaseback agreements with franchise rents in place, which were below market. But in saying that, the yields sold on 4.5%, really tight yields. So it sort of counterbalanced it to some degree, but something to have a look at and something to be aware of when you get to that, or if you're getting close to that market rent review process. Property specifics, what's the location? where's the location, what's the exposure, planning zone, is it on the homebound or city-bound side of the arterial? Yeah, what's the competition in the area and who are they? Are they a discount fuel provider? What's a side area and what's the potential for alternative type uses? And then, of course, the level of improvements, size of convenience store. We're seeing major retailers pivot to convenience store sales at the moment. Fuel sales are consistently dropping across the board from all the fuel sales we get access to through the private work we do and the corporate work we do. Pretty much no operators or very few operators achieving fuel sales in the current market today is what they were pre-COVID. Now what you're seeing is higher margins being achieved, so they're counterbalancing that, but they're also increasing shop sales. So the size of the shop has a large bearing on what level of sales they'll do. And in particular, they're putting in fresh food products and other retail services and the like. The size and layout of the canopy is also important, and there will be on-site car parking provisions, as well as the potential to add value to the site as well. Potential to put a fast food restaurant on it. Can you put a car wash on it? Help diversify the income stream and help to also tighten the yield if it's an investment asset as well. So they're all of the main factors we look at, as well as some others when we're doing valuations for those types of sites. But that's it from me. Thanks for listening, and yeah, feel free to contact me or ask any questions if you have anything. Thank you.
Thank you very much, Josh. That's been really insightful and to get some of those perspectives, including on the lending side. So thank you very much. I think now, Miraz, over to you. Thank you.
Thank you, Mitch. Thank you very much, Joshua. I might just start in terms of the sale and purchase of the business itself. So this is a little distinct from what Shuba has touched upon earlier in terms of the sale of the land of the site itself, and you may encounter a situation where you're wanting to buy into a particular business. Sometimes it can be through a franchise with one of the major operators, with 7-Elevens, with your BPs. Sometimes it can be a smaller independent owned and operated business. So when purchasing these businesses, it is sort of important to understand the structure, the way the petrol station's already structured. You're going to be asking yourself questions about, okay, who owns the site? And if it's an independent operator, are you looking to purchase the business along with the land, or are you looking to purchase a business but then get a lease from the owner who currently operates it? Otherwise, it might be a case where you're coming in, if it's operated by a tenant, the tenant might be selling you the business itself and transferring the lease across to you. This would now, there's a bit of a due diligence process that occurs in terms of the purchase of the business itself as well. Apart from the points that have already been made by Shiva and Joshua, the important environmental consideration in terms of due diligence for a business sale, I think it can be important to distinguish between the fuel sales that you would be looking at and the sales that you would be achieving from the stock and other sort of services that are put in the service station. And in terms of the business itself, the important key considerations that we would be looking at is I mentioned on the slides. One of the first one would be the equipment. And now I've already sort of mentioned how the site works, whether it's going to be a transfer of lease or whether you're going to be leasing it independently. And Shiva's already covered that very well in terms of the considerations that you would be looking at when that comes into play. But another point that was made earlier in the webinar was that the equipment, the fuel tanks, pump lines, they're generally owned by the landlord. So when you are purchasing into this particular business, and when you're effectively buying the assets of the business, you're buying the equipment and you're buying the goodwill, you'd want to have an understanding of what constitutes as those equipment, whether or not you would be purchasing fuel tanks, fuel pumps and lines, And it may be the case that if you are purchasing a site and the business itself, it may be addressed in those two different documents. In terms of another thing that you'd want to think about is what's the conditions of the contract going through. For instance, if you're purchasing a business, however, not purchasing the site associated with it, you would still want to ensure that you've conducted relevant testing and made sure that the settlement of a contract would be on once you ensure that there has been no contamination that would lead to you taking on a liability at the end of the lease that you would not otherwise expecting. So maybe that consideration comes into play. It's easy to address it when it's through a sale of the site itself, where that site would be you would effectively address within those clauses who would be responsible for remediation. When you're purchasing a business, you would want to turn your mind in terms of conducting those due diligence and making sure that that's addressed in the contract of the sale of the business as well. Another point that you'll need to take into account is the in-ground fuel. You'll need to consider whether you're purchasing when coming to a purchase price, whether that is a purchase of the business as is, or whether you will be taking into account the in-ground fuel, who would be responsible for conducting that stock take. We have previously seen that there's a minimum level of in-ground fuel that has to be maintained. So it will be important to take that into consideration in terms of coming to an price point and sort of moving forward in terms of who would be responsible for conducting that stock take, coming to an agreement whether you would have certain levels of maximums that you'd want to impose in terms of that stock. Jeff has already touched quite on the financing side of it, and often when purchasing the business, you may be looking to finance. Generally, contracts are made conditional on that finance being approved. Deposit is one element that sort of comes into play here as well. Generally, what we would provide is the deposit gets refundable if the finance is not approved. However, again, it's a commercial point that both parties would sort of need to consider when going forward. I might just also touch upon the license and approvals, if there are any. Again, it would depend highly on how the site and the business is being conducted, what sort of services it offers, whether there's a cafe attached to it, whether the level of fuel that's being stored. But generally, you would be looking at ensuring that before the contract goes through, any relevant licenses, any relevant approvals are obtained. For instance, there's a notification that has to be made to WorkSafe Australia in relation of handling of dangerous goods. That generally happens if there's an occupier that changes. That generally happens after the occupier changes. There's a time limit to it, and it has to be informed. So the contract would need to be clear about the obligations, who the notification obligations rest on, when it has to be made, consequences of not sort of providing that, and the impact that it may have on the business and the transaction itself. Moving forward, employees are going to be a big part of when you're selling that business. Often you'd have employees that are working on casual basis, part-time and full-time basis. You would need to come to an agreement in terms of who would be transferring across, what happens with the employees, whether their employment contracts are being terminated. If so, you'd want to ensure that any obligations that you have under the Payroll Act are addressed. You'd also want to ensure that if they are transferring across, there's some level of this clear agreement between between the vendor and the purchaser in terms of their entitlements, who would be responsible for annual leave, who would be responsible for personal leave, redundancy payment, long service leave, if all of these obligations are applicable. So it will be a very case by case basis, depending on having reviewed your employees, their status, their entitlements. But a few things you can take into account is that redundancy pays and annual leaves often transfer across, whereas personal leave can be paid out. But that's again, you'd have to look at it from a case-to-case basis. Another thing, and here's where the franchising sort of comes in, is what are the contracts that you have associated with the business? Often it'll be the case that if it's operated under the brand of national operators, for instance, 7-Eleven, BP's, they will have a franchising agreement in place with the operator. And it can vary in terms of the site itself. It can vary. For instance, with BP, there is generally, they would require you to obtain your own site, and then you would, however, enter that they would become the fuel supplier, and they also become the supplier of, they give you the branding, they give you the, enter into a supplier agreement with them in terms of the goods that would be sold, and so on and so forth. With 7-Eleven, however, they can, often the site would be the one approved by them. So there can be variations here, but when you're purchasing this business, you'd be effectively looking at, okay, so how is that element structured in terms of the franchising? Who would be the suppliers? And how would that be transferring across? Many of these contracts would be conditional on the consent would be required from the franchisor for that to be transferred across to you, and you'd need to meet their requirements if you're purchasing into these businesses. Certainly, the contract of sale of business is often made conditional on these material contracts passing across to the purchaser. Finally, there's also an element of intellectual property. Often, again, because they're operated under the brands of the national, these big operators, the IP would generally be owned by them, and that's something to be mindful of. Again, it would, in the franchise agreement, that's where these terms in relation to the IP would generally be addressed. Apologize for that. I might just move on to the next slide, Mitch, in relation to the franchising itself. So as Shubha spoke to you about the oil code of conduct, generally what happens is if there is an agreement in place for the resupply of petrol, the oil code of conduct would apply. And when that does apply, the franchising code of conduct does not. So this is an important distinction often that has to be made in terms of when entering these franchise agreements with these national operators, because generally the franchising code of conduct is in place to ensure that there are consumer protections available for the franchisees. This is now replaced and provided by the oil code of conduct that you'd be looking at. Disclosure obligations, for instance, Shiva has talked about 14 days before a disclosure statement has to be provided under the oil code of conduct. Similar obligations exist in franchising code of conduct, 14 days before.
Raz, just conscious of time, we might need to just let people have a read of the slides, and that, that's an important distinction with the oil code and versus the franchising code.
Mm-hmm. And I think if we, do you just want me to quickly go through the key considerations?
Yeah, we may need to just keep moving along, Miraz. Yeah, but certainly everyone, I think the things that Miraz has put on the slides there are certainly the key things that we would focus on if we were reviewing a franchise agreement. So if you are in that position, they're the sort of things to be looking for and that we would be looking out for you if we were reviewing it. they can vary quite a lot. So there's certainly no such thing as a one size fits all, is there?
No, absolutely. It sort of ranges from the territory that's allocated to operational rights that you would gain within that territory, use of the IP. There's the costs that you'd want to consider. And it can vary from franchising costs to marketing costs. Sometimes they can be fit out works that could be associated with the businesses. So you really need to consider your obligations sort of when you're entering in that contract, understand the ongoing costs and make a decision accordingly. Often there can also be a need for ensuring that if there's a lease in place and there's a franchising agreement in place, that they align so that you're not left with the obligation of the lease moving forward, where you may not have a right to renew that franchise agreement. But I think I might just let everyone else read through the rest of the points and finish up there.
Thanks, Miraz. And we sort of come to time, but we do have one question we'll try to address very quickly. It might be one for you, Shubha. In terms of non-fuel items such as drinks and food, etc., where does this stand with the lease? Similarly, with a mechanic shop or car wash on the premises, I might come back to that point you made about whether or not you can sublease or sublicense.
Yes, so it does depend on what the permitted use is within the lease there. So some of them would just, if it's just a strict petrol station, then it will just say that. It does, a lot of the ones we've seen, it just says an associated, because the convenience store, they'll definitely allow. And so that will then say, an associated related sales and things. So there, it does come down to the permitted use, so you'd have to look and see as to what's allowed there. If you do want the ability to have that in the future, then that negotiation does need to happen, and for the landlord to have that included in the permitted use, so that at a future point in time, you can do that business yourself, or you can then sublease and allow someone to do that. If the permitted use doesn't have it, and you would like to bring that business on board, then it's up to the landlord to determine whether they will allow it or not at that particular point. So it's best at the time of negotiation to try and have that covered off if possible.
So we'll wrap things up there. That brings us to the end. So thank you very much, everybody, for joining us. We hope that's been interesting. Just putting up everyone's contact details again. Thank you very much again, Joshua, for joining us. Again, that was really fascinating to get your insights from where you sit on some of the things that can come up with these types of premises. So thank you very much, and do get in touch with Joshua if he can be of help with anything in your situation. So we'll leave it there for today. Thank you very much again for joining us. We'll make the webinar available when it's up on our website, and please don't hesitate to contact us if we can be of any help. In the meantime, enjoy the rest of your day. Thank you.